Hello everybody, welcome to our YouTube channel. It's Dominica from D Legal Solicitors. Thank you everyone who has been watching and subscribing to our YouTube channel. We see the questions you leave under some of our videos. We are very appreciative. We are able to assist you. We are here to continue to assist you in your immigration, employment, family, and housing matters. Today, I'm just going to do a very quick video. I always say that and I end up doing a very long video. I hope it's not going to be too long today. But today is about the grounds where Home Office will refuse your application either to enter. You're a first time applying to come to the UK as a visitor, as a student, or as a work visa, or you are in the UK already and you are now going to apply for visa to renew your visa that you have, or your leave to remain, because that's what we usually call it, leave to remain. But if you're coming out of the UK, it'll be entry clearance. So I'm talking about today the grounds where Home Office will refuse your visa or your leave to remain if you're already in the UK. There are two categories essentially: mandatory and discretionary grounds. Firstly, I must bring to your attention that as of 1st December 2020, the rules have changed. Previously, time would have elapsed and it allows you, rehabilitation period will elapse and will allow you to apply for visa, and you may still be able to be granted visa. That's no longer the case as from 1st December 2020. Before I proceed further, I must bring to your attention that the form is very clear. You must disclose every criminal offense, be it in the UK or overseas. If you don't, it will be classified as you are being deceitful to be granted your visa. That is grounds for refusal. Where a lot of people fail to, where our application may be refused, is that there are occasions where this are no longer on your criminal record. For example, in the UK, if you do a DBS check, it used to be CRB check, it may be that it may no longer appear on your criminal record. You are still required to disclose it on the application form. It is very, very clear. Hence, I've always would state here, please seek legal advice. It's very expensive. It's for your own benefit to speak to a lawyer, speak to us. We are able to assess your case and see the category where you fall. Now, under the mandatory grounds, if you have a custodial sentence of 12 months, the application will be refused. That is a quick refusal, mandatory, it will be refused. There is no buts, no ifs. And if you're a persistent offender, it means you have a disregard for the law. You may not have gotten 12 months custodial sentence, but you're always in and out. You've gotten cautions, you have got couple sentences that it's now disposed of. You've never been to jail. However, you have a couple of those that would be classified as you have a disregard for the law, and the application will be refused. And if you've committed an offense, and offenses that is classified that has caused serious harm, it may be, example of a serious harm offense may be sexual offenses. There are other ones that will be classified as very serious. It may fall under the category of terrorists. Sorry, I'm trying to get. That will be classified as very serious harm. So that is quick refusal. You will not get anywhere with that application. But come last year, Home Office have now stated that if there might be exceptional circumstances where they may allow, if you make a representation, giving them the reason. What is exceptional circumstances? It will be case-by-case basis. It may be that you've been in the UK for a long period of time, you have established family life, your children are here. It may be classified as exceptional circumstances. Again, please contact us for us to assess your case before we are able to assist you whether you are, if you've been convicted of a custodial sentence of 12 months, whether you have any exceptional circumstances. So those are the mandatory grounds. Now, under the discretionary grounds, it will be that you have a custodial sentence of less than 12 months, or you have non-custodial sentence that is disposed out of court. That's discretion. You are the hand of the Home Office. They may decide to grant you a visa, even though you've had a less than 12 months custodial sentence. It is very important that that is accompanied by a well-written representation, giving all the facts, the reason why discretion should be applied in your favor, even though you have a sentence that is now less than 12 months. This, what I've mentioned, apply to those who are even seeking for visitor visa more than 6 months. There's a different category for those who are coming here for less than 6 months. That one, if you have a custodial sentence of less than 12 months, you cannot, they may refuse it, but let me be, you will be refused if you're coming here. I'm just referring to my note to be sure that I'm giving you the accurate information, because this is very important. So if you're coming here for a entry clearance visa for less than 12 months and you have an offense committed in the UK or overseas, you got less than 12 months prison sentence, unless more than 12 months has elapsed since the end of your custodial sentence, not at the time you were convicted, the end of your custodial sentence. Then, if that hasn't happened, for those seeking visa for 6 months, it will be refused. And if it's non-custodial sentence and is you haven't received custodial sentence, it's out of court settlement, it's a disposal, out of court disposal that is recorded in your criminal record, unless more than 12 months have passed since the end of your custodial sentence, your 6 months visitor visa application will be refused. Those are the mandatory grounds for those coming in the UK as a visitor who have had less than 12 months custodial sentence, and 12 months has not elapsed since the end of your custodial sentence. I am emphasizing this so that you are aware that this is only applicable for visiting visa for less than 12 months. Any other category, it will be mandatory. And this also applies if they later discovered that you didn't disclose this, you are already in the UK, your visa will be cancelled. And I am talking about, again, the under mandatory grounds and even the discretionary grounds that I've mentioned, it at 12 months and less than 12 months. Please, before you fill those applications, again, you may think that I don't have it's not on my criminal record. I'm not mandated to disclose it. That is not the rules. It must be disclosed. Must is the language. If you are in that category, that you find yourself, you have a criminal conviction. When I say that, I think a lot of clients seem to believe that criminal conviction is only when you have gone to jail. No, you've now heard me read out of court disposal, less than 12-month custodial sentence. It could be suspended. You may get a sentence and it's suspended. That is a criminal conviction. It could be a police caution. On the next video, I think I'll be discussing about fine driving offenses, but I thought I should do more on the custodial sentence at the first video on criminality, why your visa application may be refused or your leave to remain may be refused. So please, as from the 1st of December 2020, the rules have changed. It's taking away the rehabilitation period. It's no longer applicable. And this also applies if you're applying for indefinite leave to remain and your application for naturalization. I mean, I think you appreciate the fact that if they didn't grant you leave to remain, limited leave to remain, 2 years, 5 years, or because you have 12 months custodial sentence, or because you have out of court disposal, less than 12 months, non-custodial sentence, they didn't grant you limited leave, you can be sure that is also applicable when you come to indefinite leave to remain and naturalization. I will stop here today. For further questions, we are happy to answer your questions. I will always state here again, if we don't give you detailed answer when you leave a comment under our video, any of this video you watch, it's because it's more facts are required before we are able to tailor the advice that is specific to your own case. I hope I've given enough information today, but please contact us for more information and we're happy to discuss your case. Thank you for watching and please subscribe. Keep coming back. You'll be amazed what our video can give you before you make any application. Until next time, bye-bye.